How is everybody doing? I have Marion Arsenault, which is a very unique spelling of let me see if I can stop her from having to be looked at the whole time. Let me hide that one. Okay, good. Oh no, then it pops right up. Oh, there we go. Thanks, Molly. Marion Arsenault. She has a very unique spelling of Arsenault. If you don't know me, I'm all about last names and the histories behind them. But Marion, if you live where I live up here in French Canadian Nashua, New Hampshire, we would pronounce that. We would pronounce it exactly the same way, but we would not spell it that way. Arseneault is how, and it would be pronounced Arsenault. So that's really cool. I like that. Yes, this is a live presentation. And, you know, the name of it has to do with this court case, Buchanan v. Warley, which is one that I always go back to. I've spoken about this one before, never on the Multifamily Law School classroom, which is what we're doing right now. And I'll tell you, this court case, I really delved into it this time. I really went back into the history, and it's I found a great article, Residential Segregation by Law. And this is, I think it was a 1970 law school law form treatise, and it was really well done because he went into the whole story behind the story, which I think is what makes the law so interesting. And you know, you go back and you look at these 1917 U.S. Supreme Court case we're going to talk about today. But what you really needed to understand was what was going on beforehand, and how things had evolved, and what the case law was to get to where we were back in 1917 with the Buchanan v. Warley case. You know, let me just kind of give you a little bit of a primer. You know, you've heard famous Supreme Court cases bandied about, and it's important that you understand exactly where they came from, what they did leading up to it. So, for instance, you know, of course, you've all heard about the Dred Scott decision. I think it was Taylor v. Dred Scott, or Dred Scott v. Taylor, and that was a case where a slave with his family had moved to Missouri with his family, with his owners, to Missouri, and then I think he moved up to another northern state, and then the owners were going to move back down south, and he says, "Whoa, wait a minute, no, you guys can go. I'm going to stay right here, because once you brought me to a free state, I became a free man, and you can't take me back into slavery." And that was the Dred Scott decision, and basically the Supreme Court screwed that one up, and they said, no, sorry, they can do that. And as a result of that, you started getting all these Jim Crow laws, which were primarily Southern laws. You didn't see them up here in New Hampshire or Massachusetts. They're primarily Southern laws, basically segregating the races. You know, blacks sit in the back of the bus. You know, no blacks at this kitchen counter. Those are the types of Jim Crow laws. And Jim Crow was a you know, I think it was a caricature of the black person. It was a white actor who would put on blackface for a Jim Crow song or something like that. So you had all the Jim Crow laws, which basically, you know, separated the races. But that was codified in the Plessy v. Ferguson case, which was, I think, an 1890 U.S. Supreme Court case, which came up with the title that you've all heard before, Separate but Equal. And that became essentially the law of the land, Plessy v. Ferguson. So that's where you'll hear people talk about the Plessy case. Now, what happened with the Plessy case, because I remember watching a story about the Warren Court, and Eisenhower, and the Warren Court was the court that overturned Plessy v. Ferguson. And they did that through the Brown versus Board of Education. And then ultimately everything became, cleared up in 1964 with the Civil Rights Act. But Plessy v. Ferguson was separate but equal. And, Thurgood Marshall argued in the Supreme Court for Brown versus Board of Education that, separate is separate, but it's not really equal. And that was the problem. The Supreme Court, in an 8-0 or 9-0 decision by Earl Warren, the Chief Justice, overturned Plessy v. Ferguson, and it became Brown became law of the land. Now, I also want to talk to you about this whole concept of settled law. Now, you'll hear people say, well, no, you can't do that. It's settled law. It's settled law. Let me tell you something. And of course, you'll also hear this legal term called stare decisis, which means that we rely on past precedent going forward. Listen, nothing is so sure as taxes, death, and overturning bad law. And so this whole concept of a settled law, so you can't do anything, it's settled law. If ever you hear anybody say that to try to bolster their argument, I say that's the last bastion of a scoundrel. So if you hear somebody say that, take it with a grain of salt. Okay, so here you get this situation with Buchanan v. Warley. So let me set it up for you. Around 1910, so what's happening is in the early turn of the century, 1900s, I heard somebody describe themselves as, well, we were born in the last century. And that's true. I was born in the last century, but man, it makes me sound so old. So back in the early 1900s, you had these people, you had the situation was that the, I got it right here. Hold on, let me just read to you. There were floods in Alabama and Mississippi, and a severe attack of the boll weevil in the summers of 1915, 1916. And also immigration had slowed down because of the war going on in Europe. So all of a sudden there was this labor shortage. So the manufacturing plants, the factories up north needed more labor. And so you start to see a migration of African Americans from the south moving up to the north. And many times they didn't get all the way to the north. They stopped in places like Louisville, Kentucky, which is where we're going to be focusing on today. And as a result of that, there was started to be a little like, hey, this is a white community. Now we get more black people. And they started to draft rules. The white folks were drafting rules as to really zoning rules. Where can black people live? And you really started to see this quite a bit up until about 1910 through 1917, especially in, let me give you an example. In June of 1910, a Negro lawyer, and I'm going to read it straight. So if I say anything, or don't use the most effective term today, I'm not going to say the N-word. Okay, I'm not going to do that. But if I say Negro, it's because I'm reading it, and that's the way it's written right here. And a lawyer and his school teacher wife purchased a house in McCullough Street in Baltimore. Now, Baltimore was like the hot spot of all of this legislation for zoning, racial zoning laws. They bought it in the Druid Hill Avenue in Baltimore. And what Baltimore did is they actually drew lines. They drew racial lines. White people over here, black people over here. This one particular couple, black couple, they moved into the white section. How dare they? And of course, the residents of that street called a protest meeting. White teenagers harassed the newcomers, and certain politicians began a summer-long agitation for legal action to halt the inundation of white neighborhoods. And then there was a drive for a municipal ordinance of some kind, and they found two sponsors. One of them was this guy, Milton DeShiel. Now, I have read the book, The Color of Law, written by Richard Rothstein. Saw the guy speak down in Cambridge. He's been on my podcast twice. His daughter is now running his business. But he wrote about this Milton DeShiel as being a rabid racist. And he was an attorney in Baltimore. And in early October, they succeeded in bringing their plan, which provided for the designation of an all-Negro and all-white street blocks before a public hearing of the Committee on Police and Jail of the City Council. They passed this legislation overwhelmingly. The Democratic and whoever wrote this this article really lays it out from a Democrat and a Republican standpoint. So I'm just reading. I'm not picking sides. He says the Democratic City Council passed the ordinance establishing separate white and Negro neighborhoods in early December and sent it to Mayor John Mahool for signature. And then what happened as a result of the passing of this, you started to see city after city down in the South start to pass the same type of legislation. Baltimore, Richmond, Virginia, Norfolk, Virginia, Ashland, Roanoke, and Portsmouth, Winston-Salem, North Carolina, Greenville, South Carolina, Atlanta, Georgia. In the next 3 years, the laws spread westward to Louisville, St. Louis, Oklahoma City, and New Orleans. The story of residential segregation from 1914 to 1917 then focused internally on Louisville, Kentucky. And this is really where it gets interesting. And this is where the story takes a turn. Now, I want to explain to you something. For those of you that, let me see, where did I leave my little story about my friend? Oh, don't tell me I don't have it here. Rosa Parks. We all know. Oh, here she is. Hello, Rosa. A lovely lady. Very lovely lady. So we all know about Rosa Parks. She was not the first person to resist bus segregation, but the NAACP believed that she was the best candidate for seeing through a court challenge after her arrest for civil disobedience in violating Alabama segregation laws. Okay, so my point I want to say is that many of these famous Supreme Court cases don't just happen. They're actually planned, and they're set up to get to the Supreme Court and challenge bad law. So there's always got to be a court case somewhere. Like, for instance, Brown versus Board of Education. Everybody knows Brown versus Board of Education. And they all know who argued that case in front of the Supreme Court. It was Thurgood Marshall. Did Thurgood Marshall represent Brown? No, he didn't. He represented another plaintiff. And they just aggregated the cases and said, well, hey, Thurgood, you're pretty good. Why don't you go and argue the case for us? And he did. And that's why Thurgood Marshall argued the Brown versus Board of Education, because the cases were aggregated. His client was not Brown. I don't remember the name of his client. I think it started with a B. If anybody, there's a question there. Somebody jump on Google, find out who his actual client was. Okay, so in this particular case, it all hemmed around Louisville, because guess who showed up to try this case the same way they did with Rosa Parks many years later? The NAACP. They needed to find a plaintiff, and they didn't like the Louisville law. So let me read you. You're gonna love this, and this is gonna be a little walk down memory lane, a little history lesson here. And this is absolutely fascinating. It's fascinating to me that this is how people thought just 100 years ago. No, actually, it was more than 100 years ago. It was a lot more than 100 years ago. No, it wasn't. It was only 1917. So yeah, it was 167 years ago. And I'm 72, so how much? You do the math. All right, so here's the case. In mid-November of 1913, and I'm going to set it up. We're going to set up the situation here. One W.D. Binford appeared at his own request before a weekly luncheon of the Louisville Real Estate Exchange. Now, that was as a group. It's like your local real estate investment meetings, okay? Binford was an employee of the mechanical department of the Louisville Times and the Louisville Courier Journal, which was a very liberal, not liberal, meaning very racist newspaper. That was the racist newspaper. The other paper wasn't so racist. He had written the first article calling for the enactment of a segregation ordinance in Louisville. I felt it my duty, Binford told the exchange members, to appear before you and give further testimony in an endeavor to enlist you in a cause that I believe means much to you, not only as an individual property owner, but as an organization that practically controls the rental of property in the city of Louisville. Okay? Oh, he's doing God's work. He's just looking out for himself. Which is always another argument that people always say, like, oh, they're going to ruin the property values. I was on the Board of Assessors in my city 30 years ago. I'm going back on the board. The mayor asked me to go back on the board here in town. And I said I'd do it for a year just to help them out because they've been embroiled and embattled. And I said, okay, fine, I'll help you knock down these commercial properties. But I'm only doing it for a year, then I'm off. But one of the biggest arguments people say is, well, they do that, my property values are going to go down. No one's property values ever go down. And the one thing that is so short-sighted in this guy's argument is, well, if you segregate and you say this one huge group of people cannot ever become a customer of yours by buying your property, you just hurt yourself anyway. You've hurt your property values. If I know that my competition, if I'm looking to buy your property, I know the competition is half gone, well, I'm not going to pay as much. You ever think of it that way? Okay. So what happened was they went to court. The thing ended up passing. It passed the Board of Councilmen. They put together a charter that said that, let me see if I can find, oh, shoot. Let me see. The action of the ordinance. Okay, now let me just say I'm not finding, but what happened was it passed the Board of Councilmen 21-0. Okay, and as soon as it did, I'm trying to find the actual wording. Because it's important that you understand that this was considered a police power, that it was a way to control people, not the property, the people, and it was done using the police power of the government. That is going to come up throughout our conversation, and it's going to be very important in the way the Supreme Court decides this case. Okay, I apologize. I'm one of the most. Oh, is it? Oh, I'm sorry. I can't find. Basically, what it said is that what the actual wording, the way the case said was that. Oh, folks, I apologize. Here's what happened. You couldn't have one race move into a street if it shifted the races by 50%. And so basically, if you're on a street that's half and half, you have to sell to your own race. Or otherwise you'll tip the balance and the real estate contract will not allow to go through. So what happened was that along came, okay. Oh man. Oh, okay. So here we go. Along comes Buchanan and Warley, and they were friends. Black man, white man. Hey, one thing I noticed about Kentucky is that is like one of the most, as far as biracial marriages. When I owned property down in Kentucky, I was amazed at the number of people biracially married, biracial couples, and it was just like no big deal. It's like, hey, that's my husband, that's my wife. It was like nothing. And that's the way it should be. That's the way it should be. And then that's the way it is down in Kentucky. Anyway, so what happened was we're now moving to the courts. Now the NAACP has to find a plaintiff that will allow them to take it through the court system so they can get it overturned. So they can take it to the Supreme Court and show that it's a violation of their constitutional rights. So who was that plaintiff and defendant going to be? Now, here's the problem. You're dealing with real estate. And typically, if the deal doesn't go through, the parties just go their separate ways and they find another house to live in. So you had to create a case between a plaintiff and a defendant who are both willing to go the distance for the case. And this caused a problem because, well, if you're going to do that, you're going to have to pay the money to go all the way up to the Supreme Court. And, well, nobody was coughing up the dough for the longest time. Ultimately, this helped the NAACP get out there and raise some money for their organization. They had only been in existence for a few years before this got started. So they were a fledgling operation at that time. It was decided to challenge the ordinance in both civil and criminal cases. On August, 2 weeks after Segregation Sunday, Arthur Harris, a black man, took possession of a house at 630 19th Street in a white block. Harris was promptly summoned to appear in police court. He was found guilty of violating the new ordinance, and the NAACP had its first case. Okay, so that's the criminal case. At the same time, the association moved in a carefully planned civil action, carefully planned. And here's how they did it. In setting up this test case, it arranged for William Warley. All right. Now, William Warley was a good guy. He was a let me just tell you about William. He attended Central High School. He graduated from Louisville State University. He worked at this dinner club, and he secured a job at the United States Post Office. He was also a lawyer. The white real estate agent, Buchanan, and Warley, the buyer, wanted the ordinance overturned. Warley ended up founding, years later, he ended up founding the Louisville News in 1912 and served as its editor. He married and had 2 daughters. Louisville's Republican Party refused to back Warley's campaign for a seat in the state legislature. With Democrats openly hostile to African Americans, this and other instances of lack of support led some African Americans to form their own Lincoln Independent Party. And he died after complications from tonsillitis. All right. So in setting up this case, it arranged for William Warley, president of the Louisville branch of the NAACP, to offer to buy from Charles Buchanan a plot, a lot of land. The lot was located in a white block, and Warley's letter contained the following proviso: that it is understood that I am purchasing the above property for the purpose of having erected thereon a house which I propose to make my residence, and it is a distinct part of this agreement that I shall not be required to accept a deed to the above property or to pay for said property unless I have the right under the laws of the state of Kentucky and the city of Louisville to occupy said property as a residence. Buchanan accepted Warley's offer. Warley refused to make payment on the house, contending that he would not be able to occupy the house because of the segregation law. Buchanan sued for breach of contract, and the civil test of the law began. On the day before Christmas, Judge James Gregory handed down his opinion in the criminal court. And then remember, we're all saying this is a police action. So that's why you always hear this. The courts were set up a little bit differently back then, but nevertheless, when you get to the Supreme Court needs a reason, and they look to the police powers within the Constitution to determine this case, which I think, and many others do, that was the mistake. But remember, it was 1917. We didn't have the civil rights era. We didn't have the growth of the power of the 5th and the 14th Amendment. He handed down his decision, rested on 3 points. First, that the ordinance was extremely mild in its operation. You guys, you're getting all ruffled. It's a very simple ordinance with a scrupulous regard for property, not for person. Second, the court agreed with the city attorney's contention that the ownership of the property was not absolute and unqualified, but might be regulated by the state. And finally, the court considered the whole question to have already been decided in this U.S. Supreme Court, first in Plessy v. Ferguson, and then also in another very interesting case called the Berea College case. Now, Berea College was a college that was started after the Civil War in Kentucky, and it was a totally integrated school. Blacks and whites, anybody could go to this school. And then, of course, Plessy v. Ferguson comes down years later after it was started, and Plessy v. Ferguson says, hey, separate but equal. And all of a sudden, some state legislator from Kentucky steps up and says, hey, well, you can't have this college with blacks and whites going to school together. We have separate but equal. So there must be a reason, there must be a separation between the two. Now, they're like, hey, leave us alone. Obviously, we are the only college in Kentucky that this is going to affect. This is like the equivalent of what's called in the Constitution a bill of attainder. This is like you're just picking on us. Leave us alone. And it went all the way to the Supreme Court. And the Supreme Court, they argued it on a corporation argument that the states have the right to define what corporations can and cannot do. And that's how the Supreme Court read it. And they said, we're going to let that Berea law stand. Berea, you have to be black or white. Does that mean it's settled law? Was it settled law then? Yeah, it was. It was settled law. So much for that argument. All right. So they lose. Buchanan and Warley lose. They go to the Court of Appeals. What happens to the Court of Appeals? Well, what do you think? It gets shot down in the Court of Appeals too. So all of a sudden, now we're up to the U.S. Supreme Court. And of course, the decision in the appeals court was a unanimous one. Let me just read to you one of the decisions, what they said, referring to the contention that segregation of whites and Negroes could lead to segregation of Republicans and Democrats. And we already have that now, don't we? And Protestants and Catholics. The court dismissed such reasoning as a time-worn sophistry, which has been answered in the Plessy case. Finally, the court reaffirmed on the basis of the Berea College case that the state is fully committed to the principle of separation of the races whenever and wherever practicable and expedient for the public welfare. All right. Wow, they're losing. I mean, guys, just think about the mindset. I know, people on this call, all different types. Think about the mindset back in 1912 that they lived under Plessy v. Ferguson, where everything was just totally separate. This is what's called de jure segregation. This is versus de facto segregation. I say de facto segregation, one starts without the other, but de jure segregation perpetuates segregation. And if you go back in this country and you look at the laws and how the laws were created and what they were done, especially housing, the reason why there is such a disparity in races now, and there, you can easily see that the African Americans have gotten the short shrift through the years. You go back and you look at that's legislation and how they segregated the races, especially in housing. And that's why I'm using the Buchanan case to prove this point, is because this identifies the de jure segregation, because even though Buchanan was decided correctly, it laid the groundwork for years more of the government setting up policies that were racially discriminated against the blacks. Okay. Now the NAACP is ready to rock and roll. We're going to the U.S. Supreme Court. All right. So they hire a lawyer. They hire a law firm in Louisville. But the thing about the Louisville law firm is some people in the NAACP didn't really like the lawyer. So they said, okay, we'll hire you, but we're going to do it in such a way that that we want William Story to also sit co-counsel, sit second seat. William Story was a president of the NAACP, which is typically a figurehead position. But back, William Story was not that kind of a guy. He actually got up there and he argued the case. Let me see. I'm going to read you some of the quotes from William Story. Story pointed out that according to the law, the worst this particular zoning law, it basically said that the worst white man was seen as a better neighbor than the best colored man. And that's, you think about that, that's really true. So he sought to discredit the notion that the ordinance applied to both Negroes and whites alike. Recalling Anatole France's reference to the justice which keeps both rich and poor from sleeping under bridges, Story said that a law which forbids a Negro to rise is not made just because it forbids a white man to fall. A discrimination against one race in violation of the Constitution is not less repugnant because another race is also discriminated against. The rationale behind the city's police power argument was also questioned. The white majority had decided to take away the rights of Negroes to live where they chose on the grounds that they, the whites, might engage in lawless attacks against the Negroes. The only policeman who ever fancied that such a police power existed, exclaimed Story, was the wolf in his dealings with the lamb. And he's absolutely right. And in conclusion, Story said, Story firmly tied together the moral and legal arguments by emphasizing that the question is whether a majority of the people dwelling in any locality may say to the minority, you shall not have the rights of other men to live where you please, not because you have violated any laws, human or divine, or have done anything to make you bad neighbors, but because you are what God made you, and because we consider ourselves your natural superiors, no matter what our habits or our qualifications, because our complexion is different. I tell you, folks, this is, I look at this, it's crazy to me, but the Supreme Court came down with some very interesting arguments for and against. It ultimately was, the city attorneys had reasoned that Negroes could still own property. Okay, so, we're not saying you can't own property here in Louisville on white blocks. You can own it. You just can't live there. You can rent it out. How does that sound? It is elementary. Property is more than the mere thing which a person owns. It is elementary that it includes the right to acquire, use, and dispose of it. The Constitution protects these essential attributes of property. That's what so the city attorney said, hey, you can own it, you just can't live there. And the Supreme Court said, nah, that doesn't work. You get full right. You get full right and title, full, you get to benefit everything below it, everything on it, and everything above it. Full fee absolute is a type of ownership you should be entitled to. And the issue that the Supreme Court was wrestling with was that the heart of the matter, according to the court, was exactly what Story had claimed. May the occupancy and the purchase and sale of property be inhibited by the states or by one of its municipalities solely because of the color of a person's skin. The city had claimed that under the police power, such inhibitions on the use of property were permissible, and that the public welfare in Louisville had demanded their enactment. It is urged, said the court, that this proposed segregation will promote the public peace by preventing race conflicts. Au contraire. All right, so it all came down to, it said it also, the right of which the ordinance annulled was a civil right. Oh, get a load of this. This is how ridiculous and how short-sighted these people are in their arguments. This goes back to my original conversation about reducing the value of a property. Oh, my property values will decline if this happens. Those people that say that never really think that one through, because in this particular case, two things are going to happen. One is that the people who own the property just lost half of their marketing base. Now we can't sell to that other group. But then they also say here that what's happened to white people, well, basically what I just said, this ordinance also worked against white people. The ordinance violated the due process clause of the 14th Amendment and could not be allowed to stand. So what happened was they overtook the one. So there's one of the first cases with NAACP took to the Supreme Court and a test case, and they won. But did they really win? And here's the problem with this case. In this particular case, the Supreme Court used the police power. They didn't use the 5th and the 14th Amendment. They did tap into the 14th Amendment because of the police power, but they didn't allow it to be determined under equal protection and equal protection clause and the due process clause. So therefore, what happened after Warley was that racist city planners were now given a blueprint on how not to write legislation that would be deemed unconstitutional. They now could say, oh, well, we're not violating Warley. We're doing it this way. Read Warley. It'll teach you that that's the wrong way to do it. We're doing it differently because we're not relying on, geographical location. We're doing it based upon these other reasons. And they used it like a club for the next 1964 till the civil rights law, and really it was more like 1968, especially when the Fair Housing law came into being, and the FHA, Fair Housing Administration, had to overturn all of their ridiculously racially discriminatory background. So that is why I think that Buchanan v. Warley was a great case. It was decided correctly, but used in the hands of the wrong people. And I tell you, if read that, The Color of Law, Richard Rothstein, he did a great job in presenting all the different levels of de jure segregation that this country has used against the Black people. I tell you, the one that gets me every single time I think about it, the one that burns me up the most, is how the Veterans Administration with the GI Bill and all this great stuff, oh, you can get a GI loan, you get a VA loan. They treated Black soldiers differently than white soldiers when they got home. Levittown is a perfect example of this. Now, I'm citing the VA out of this. Essentially, the VA took the rule book from the Federal Housing Administration. So when the VA was starting to set itself up to give out loans, they said, hey, we need an underwriting manual. Where can we get one? Hey, go get it from the FHA. The difference were the customers of the VA versus the customers of the FHA. Not really different, but my point is, you had people laying down their lives, putting their lives on the line, taking their time out of their busy existence to go fight for this country, all of them. And when they came home, that institution that they swore allegiance to is now treating them differently based upon the color of their skin. And Richard Rothstein in his book talks voluminously about this particular disparity. That Levittown, we all have heard of Levittown. Billy Joel was from Levittown. Bill O'Reilly was from Levittown. I mean, these guys, that 18,000 homes, I think, were built in that particular neighborhood. Guess how many African Americans? Guess how many? Zero. They were not allowed because the government would not insure mortgages for African Americans. And so therefore all the mortgages, all the government sponsored mortgages in that community, which was all government sponsored, were not given to Black people. even if you fought right alongside another guy in the war, you couldn't live there because the government controlled the insurance on the mortgages. It's just unbelievable. And this Warley case, we were this close to getting it right, and they blew it. And it left another 50 years of racially charged housing laws and de jure segregation by our government. Okay, folks, that's it. Hope you enjoyed this. If you have any other cases you want me to talk about, this is a long one because I just this one is near and dear to my heart. So and it's because of the VA loans. Like, my dad benefited from it, and friends of mine who are African American, they didn't get the same benefit that I did, which is ridiculous. So, all right, folks, great to see you. I'll see you next Tuesday for the next lesson. I'll have the court case out earlier, and you can all study up on it. We can talk about it. Talk to y'all soon. See ya.